based on sex. So we have new regulations that just came out in May, and that's what we're going to talk about today. Just a few things. We'll be checking the chat, and as we go along, you're welcome to ask questions. I'll let you know if this is something that we're going to cover moving forward. There probably will be a lot of questions. I certainly have a lot. These were just released, and it's over 2,000 pages, and it's a lot to digest. So, but I'm really glad you're here. Mercedes will be monitoring and helping me move slides around. This has certainly been a learning experience with remote presenting. So, let's get started. Next slide, please. Okay, so here are our objectives today. We're going to look at the purpose and the overview of Title IX and the new regulations, the new definition. The definition has changed. Grievance processes, having really dialed in grievance procedures is key in this. They're really tightening up on your grievance process, and part of that is the personnel and training. A lot of this is at the district level, so it's an awareness piece for those of you who are in the school, so you know how investigations will proceed and who will potentially be in charge of those investigations, and then some resources for you. Okay, so this presentation, I can't promise much entertainment. It's very law heavy, very jargony. And so here's what I got for you. Yeah, they dropped into our laps a 2,080 something page regulation book and dropped it on our desk. Supposed to be last October, and said, here you go. Your assignment is due in August. And good luck with that. And I looked up War and Peace has 1,222 pages, and I'm wondering if I would prefer to read that and have that be my assignment. But nevertheless, this is what the assignment is from the U.S. Department of Education, so we're going to do our best, aren't we? So here is the purpose and overview of Title IX and of the regulations. So it's the Education Amendments Act of 1972. It's a comprehensive federal law that prohibits discrimination on the basis of sex in any federally funded education program or activity. So part of the reason they revised the regulations is that sexual harassment was never explicitly addressed as part of Title IX. So these new regulations were intended to clarify sexual harassment as a form of discrimination, what sexual harassment means, and to also tighten up policies. They felt like there was a lot of inconsistency, and they wanted to really make sure that the processes were clear and fair for both parties. And then to make sure that we're requiring the survivors supportive measures. They talk a lot about supportive measures for both parties. There seem to be opinions that there was inequitable treatment in one way or the other for the parties. So I'm going to be checking my notes as I go along, because I noticed that's not something that I get to do. Oh, I don't know if any of you have seen the Captain Picard. I'm wondering if I can share my screen. I'm going to show you. This is like the one other time I'm going to make you laugh. Oh, she didn't let me. So I don't know if you've seen that meme with Captain Picard that says how it feels waking up every morning in 2020. And he says damage report. And this is just such a weird time. So I'm glad that we could all kind of try to achieve some kind of normalcy. So back to our definition of sexual harassment. This has changed. So this means conduct on the basis of sex that satisfies one or more of the following. So school employee conditioning, education benefits, non-participation in unwelcome sexual conduct. So this is more teacher to student or teacher to teacher, a quid pro quo. Unwelcome conduct that a reasonable person, and they don't define what a reasonable person is. That is up to us, you, to decide what reasonable is, would determine is so severe, pervasive, and objectively offensive that it effectively denies person equal access to the school's education program or activity. I want to point out that the part where it says and that I have underlined, this used to be and or. So people have differing opinions on this because how do you define severe? How do you find objectively offensive? So if you have to justify the conduct based on all three, this can be a difficult assessment to make. So moving on, we're going to focus a lot on the grievance process. This is something that they have made very clear exactly what needs to be in your grievance process. And they're going to be very particular on this. And you need to have them posted. You need to be very clear with those who, your complainants and respondents. This is something you really need to focus on a lot moving forward. So the overarching principles of the grievance process, well, just as a reminder, August 14th is the deadline. I don't know how lenient they're going to be. We are talking about the U.S. Department of Education. They're asking a lot. It's a heavy lift, especially for K-12. The last time they did a lot of revisions, it really affected higher ed. This is a heavy lift for K-12. And so I'm not sure how much lenience. They're not saying that there's going to be any flexibility. So the grievance process itself cannot discriminate against a complainant or a respondent. And I underline those because that's the terminology in the new regulations that they're wanting us to refer. So what you might think as a perpetrator and a victim. So a complainant or a respondent. Attorneys prior to the new regulations were preferring claimant and respondent. When you're dealing with sexual harassment allegations, they weren't necessarily as comfortable using complainant because it sounds like someone's complaining. But that's what the new regs are asking us to consider the parties. And so the remedies, and just as any civil rights law, is to restore or preserve equal access to schools' education program or activity. And that's really fundamentally what all the civil rights laws are about. So here are the 10 requirements of the grievance procedures. And I'm going to be sending this out to all of the Title IX coordinators in the state because I want you to have, and I'm sure some of you are not the Title IX coordinators, but I do have a listserv. If you want to have this PowerPoint, we're also recording this so that you can view this later. But these need to be explicitly stated in your grievance procedures. And so we need to treat the parties equitably. We need to have an objective evaluation of evidence. A lot of that's going to come down to the team of investigation. Training, we're going to talk about the training for staff. There needs to be no conflict of interest. There are a lot of opinions about that. Conversation going on about conflict of interest, a presumption of innocence. We need to have reasonably prompt timeframes, and they don't define that for us. Again, who is a reasonable person? What are reasonably prompt timeframes? That is for each LEA to decide. Providing a description in your grievance procedures of a range of outcomes, a standard of evidence. We'll talk about what that means, a right to appeal, a description of a range of supportive measures and privileges. So what activates an investigation? This has changed a little bit. The first thing, well, I'll go with the first bullet. So it's once you have actual knowledge of these allegations. And the next bullet tells you what actual knowledge means. So, and we need to respond promptly. And so actual knowledge means notice or allegations received by the Title IX coordinator, a school official with authority to institute corrective measures on behalf of the school. So those of you who are building administrators, or any school employee. So this is a big responsibility, and it's something that you're going to need to really think about in your schools and in the district, that your employees have a responsibility, any school employee, to provide, if they get actual knowledge, they need to be reporting it, because a lot of the terminology they use is deliberate indifference. So if an employee has actual knowledge and they don't report it, that's acting in deliberate indifference. And that's really the sticking point for allegations of breaking your grievance procedures. So really training your employees that if you are told that there is any form of sexual harassment, please report it to me, and then you need to involve the Title IX coordinator. So when you do get that actual knowledge and you haven't started an investigation, you immediately need to treat that person, the complainant, as treat them as a complainant, so you have notice. So that's where you need to put in your supports. So that doesn't matter if they reported it or a third party, or if they ever file a complaint. So you need to immediately treat them as a complainant. Something else that has changed is that any decision to file a formal complaint, there's no statute of limitations. It used to be that they could not file a complaint after 180 days. So that's gone away. So they can file a sexual harassment complaint at any point in time. Okay, so this is where I need my notes. So here's what I mentioned as far as reasonably prompt timeframes. The Department of Ed feels that you, in whatever circumstances in your district, whatever resources you have, that you are in the best position to decide what reasonably prompt timeframes mean. You just have to state it explicitly in your policies. And so you have to decide what that balance is between fairness and accuracy. So it doesn't permit a recipient to conduct a grievance process without a set time frame. So you really need to lay this out. What is our time frame of response going to be? But you can, so it has to be designated with each process, what the time frame will be for each phase of the process. That includes the appeals or any informal resolution processes. And we'll talk about informal resolution later on. That is an option that you have, but it's not a requirement. And you must notify both parties when you, if you are requesting a short-term delay. So there are circumstances when you can delay an investigation past your timeline. So it just has to be very limited and temporary and justified. So with the past regulations, there's a question of law enforcement. So when I was reading into it and trying to make sense of where law enforcement came into this, because sometimes schools and districts will think, oh, we can't conduct our investigation if law enforcement is also conducting an investigation, we need to wait. That's not true. But you are working with law enforcement. So that relationship needs to be coordinated. So what the regulations say is that if you are prohibiting the delays based on law enforcement, that deprives the recipients of flexibility to work effectively and appropriate with law enforcement. So we can't prohibit delays. But then there's that balance that you have the discretion of balancing by not permitting to apply a delay or an extension that is temporarily limited. So they're declining to say how many days that might be. So you just need to work with your district administration and law enforcement to decide, okay, I think this circumstance warrants a delay, how many days we need to, and you need to communicate that to the parties. Okay, so next slide. Isn't this all exciting and interesting? I wasn't going to promise you an exciting presentation, but very important. And we want to make sure that we're on target. Okay, so here are your obligations of responding. So again, prompt and equitable. So we need to be equitable with both parties. Remember this presumption of innocence. And we talked about deliberate indifference. So if you receive this information, you need to act on it promptly and not just say, okay, well, let's wait and see. They probably didn't mean that. And you know, it's, that will come off as deliberate indifference to an allegation. So, and this is just in light of the circumstances. So the Title IX coordinator, which a Title IX coordinator is at an LEA level, or a charter school has to have a Title IX coordinator. So you at the school level, you're not a Title IX coordinator. You just need to involve the Title IX coordinator when you have the actual knowledge. So you have to promptly contact the complainant to discuss supportive measures. So some of examples of that, and it really is dependent on what you have available at your school. What would be, it's individualized on what's going to be the best situation for the parties that are involved. And so some of those might be no contact orders, some academic accommodations, and that doesn't just mean where you're sitting in the school or what classes you're in, but also how is it impacting their academic work? Are they able to engage in learning? Because if there is someone who's experiencing sexual harassment, that's going to impact their social emotional, it's going to impact their health and their mental health and their physical health. So there might be some extra services that you need to provide. And if they have a 504, there may be some, or an IEP, there may be some disability services that you need to provide. So those are just some examples of supportive measures, but it's not exhaustive. So those need to immediately be put into place, regardless if a formal complaint is filed. But you do need to respect their wishes with the measures. You can't force anything on them, but you let them know what's available. And at that point, you need to explain to them explicitly what the grievance process is, what the process is of filing a complaint. So definitely there's a caveat here for schools who are worried, well, what if, what if there's an immediate threat to the health of the complainant or someone else in the school? So there's a school safety issue. You can remove a respondent for physical and health safety reasons, but definitely refer to your district policy, involve the Title IX coordinator to determine what qualifies as an immediate threat before you remove a student. Next slide. Okay, so the rule defines what a formal complaint is. It's a document. Big part of these new regulations, document everything. That is a big part of this. Because they're tightening up on procedures and policies, that's something that if OCR were to come in and do an investigation, or if there were to be a court, someone were to sue the district, they're going to want to see your documentation and that you've been following your policies and procedures. So, but the formal complaint, if the complainant wants to file, then it has to be signed by the Title IX coordinator. And then at that time, and this is something that is new, right? Or something that I didn't understand in the past regulations, if this was still the case. But when they file the formal complaint, they have to be participating in or attempting to participate in the education program or activity of the school with which the formal complaint is filed. So let me read that again. So at the time of filing a formal complaint, a complainant must be participating in or attempting to participate in the education program or activity of the school with which the formal complaint is filed. So they have to be actively participating. And there's another part of the rule that has to do with as far as participation or where sexual harassment has occurred that we'll talk about moving forward. But keep in mind that there's this participating in or attempting to participate in a current program. And then it can be filed by anyone. It can be filed on from any person or group. Okay, so when you receive allegations and you act promptly, you have to provide a written notice. And this is to both parties. It needs to be provided simultaneously. You don't want one or the other parties to get the written notice before the other. They need to receive them at the same time. So you describe the allegations and what meets the definition, if it's severe, pervasive, or objectively offensive. So you need to describe that. You need to describe that there is a presumption of innocence and they both have equal rights. A statement that the parties are entitled to an advisor of their choice. This person can be anyone, any person. That can include an attorney, a parent. It's good for you to know who that person is going to be, but that advisor can be a part of every part of the process. And a statement that they can request to inspect and review certain evidence, information regarding code of conduct and false statements. So your code of conduct in your school is going to come into play. And then informing them if there's an opportunity to engage in an informal resolution, which is not a requirement, but it's something that you can provide if you choose. The determination of a dismissal. So determination of a dismissal means there are certain conditions where you can dismiss a complaint. And so you need to tell them what those conditions are, and that they have the right to appeal. They have a right to appeal any decision that the district, the LEA presents to them. And then the range of possible remedies and disciplinary sanctions following the determination of responsibility, and which standard of evidence will be used to reach a determination. So just so you know, as far as informal resolution, nobody really wants to involve OCR in anything. That's the Office for Civil Rights. But part of all of the requirements in this rule can be quite expensive, honestly. I haven't talked about those. They can be quite an investment. So if OCR does offer a facilitated resolution between the parties, if a complainant does decide that you are not following your policies or are not acting on their behalf, they can file a complaint with the Office for Civil Rights. And so sometimes this facilitated resolution between the parties can be advantageous to notify them that this is a possibility, but they can come in kind of as a mediator. And it's not a formal complaint investigation, but just know that's a resource that I don't think most schools want to call OCR and get them involved. But that is something, if it comes down to, especially if a party were to complain to the Office for Civil Rights, you can let them know, oh, they also have a formal or a facilitated resolution that we could try first before we go in the direction of a full-on investigation. Okay, so we talked about grounds for dismissal. So there are mandatory grounds for dismissal. So you have to dismiss a complaint that does not describe conduct that meets the definition. So remember, that's severe, pervasive, and objectively offensive. So you must dismiss a complaint that does not describe that. It doesn't mean that you can't follow through with your own code of conduct and discipline procedures with your own code of conduct. But as far as a formal Title IX complaint, it needs to be dismissed if it doesn't meet those qualifications. If the complaint alleges sexual harassment that did not occur in the school's education program or activity. So this is something that my perception in the past was that if these students were in your care and there was sexual harassment at any time in any place, it would apply to Title IX. But this is pretty explicit, saying that the sexual harassment has to take part in one of the school's education programs and activities. So that's where you're going to make a distinction on, is this Title IX or is it not? Where did it take place? Now, that doesn't mean that if you receive an allegation of sexual harassment, let's say cyberbullying or cyber sex, what is it called? Sexting and things like that. If you're receiving complaints like that, and it's going to impact a student's ability to access their education if they're feeling afraid, then you can provide supportive measures and move with your own code of conduct policies, but it doesn't move to a level of Title IX unless it occurs in a school program or activity. Complaint alleges sexual harassment did not occur in the United States. That's more, I think that happens more with higher ed. And then the complainants can still be addressed under the school's code of conduct. And that's what I've explained, is that you can still address it there, as well as Title IX or in replacement, if there's grounds for mandatory dismissal. So moving on. So discretionary dismissal. So this is when you can decide, should we dismiss this? And of course, all parties are able to appeal at any point in time if they disagree with your dismissal. So if the complainant notifies the Title IX coordinator in writing that the complainant wishes to withdraw the formal complaint or some of its allegations, there's a caveat there. If the respondent is no longer enrolled in the school, but remember, there's no statute of limitations of filing a complaint. And then if specific circumstances prevent the school from gathering evidence sufficient to reach a determination about the allegations. I was trying to think of examples of what that would mean. I don't know if maybe there are things like court records or that they can't obtain that would help to reach that determination. I don't exactly know what that would look like, and I'm not an attorney and I'm not an official investigator, so I'm not quite sure, but there could be circumstances that would lead to a dismissal. But the caveat with bullet number 1 is that they state in the new regs that you can still proceed with an investigation if you feel like the dismissal from the parties is inappropriate. So let's say the Title IX coordinator feels very strongly that this needs to be investigated. The Title IX coordinator can sign a formal complaint. And in any time that allegations are, or a formal complaint is given, it needs to be signed by the Title IX coordinator. It always needs to be signed on a document. But they can do that. The Title IX coordinator can file. But the Title IX coordinator needs to remain impartial. So probably shouldn't serve as the investigator. And in most circumstances, the Title IX should not serve as an investigator, but All of the new regs are going to provide you, especially in rural areas and charters, with some challenges with staffing and training. And we'll get into that. Just remember, I'm the messenger. Don't shoot the messenger. This is not my fault. Okay, so the rights of your parties, your complainant and your respondent. So they are able to have witnesses and evidence, which includes inculpatory or exculpatory evidence, which my not being an attorney, I got to look that up. And so your inculpatory evidence would be evidence supporting that the respondent is responsible. And I had to try to think of something that would remind me of what inculpatory meant. And so I thought of, first I thought of incarcerated, but then that seemed pretty rough for K-12. So in trouble is what I came up with. Exculpatory is basically excusing them, claiming innocence for the responding party. And then you can't restrict the ability of either party to discuss allegations under investigation or gather and present relevant evidence. But keep in mind that any of these discussions need to not take place in person between the parties. This all needs to be written communication back and forth. And so you just need to be presenting equal opportunities as part of the grievance procedures. You can't choose who their advisor is. And so the fourth bullet is a little tricky when we're thinking about FERPA. That might kind of come to your mind when you're looking at access to evidence by both parties. And I don't have a lot of answers for that, but it is certainly something that people are concerned about, having access to all of the evidence. And you're supposed to provide sufficient written notice of scheduled meetings and hearings. Hearings are not a requirement of K-12. They are at the post-secondary level, but not at the elementary and secondary level. It doesn't mean you can't hold hearings, but they're not a requirement. And those are not to take place in person. Never at any point should you pair the parties together. Okay. So now that you are starting an investigation, here's the process. So you've provided the written notice, which we've gone over what that should entail. And then you assemble your investigation team. We'll talk about what that looks like. You evaluate your evidence, including the inculpatory and exculpatory evidence. Then you prepare an investigative report, which you share with the parties. This is before you reach a determination. And so you have to, at that point, allow both parties to submit questions and responses, and providing each with the answers and allowing for enough time to go through that where they can review the investigative report and give their responses. And remember, they're submitted in writing. And then you make the determination and you present that to both parties simultaneously. Okay. I wrote in my notes here that you need to let them know any disciplinary sanctions imposed on the respondent and any remedies provided to the complainant. Okay. Remember, I'm looking at my notes over here because this is a challenge when you have an online platform and you can't do your presenter view, because then I'd be sharing my screen with you and you'd see my presenter view. So, but we're working with what we have, right? All right, so we're going to look at who's on the team. And this is going to present a great challenge. For our larger districts, they might have the money and staff to fill all of these positions. And remember, they're going to be strict on these. So they're going to have to troubleshoot how to do this. So on the team, you have the Title IX coordinator, and then you have an investigator, and then you have a decision maker. Now, in circumstances where it's hard to put together 3 different people if you're in a rural area or a charter school. So the Title IX coordinator can serve as an investigator. They cannot serve as a decision maker. A decision maker needs to be an unbiased party that will be reviewing all of the evidence and making the decision. Now, of course, when I'm hearing conversations, they want you to have a whole group of people who are decision makers. That's really hard to do in these circumstances. They're supposed to be unbiased, and there are a lot of conversations around that. How can a district be unbiased? But you're going to pick your reasonable people. And I trust that I've worked with all of you. Y'all are reasonable to me. So you've got the Title IX coordinator and the decision maker. And so the big thing here is you have to be trained. So you have someone who's trained as a Title IX coordinator and someone trained as a decision maker. This can be tricky, and you have to demonstrate to the Department of Education that you are trained. I have a certification in civil rights investigation and a Title IX administrator. I have to go and get retrained because of the new regulations, and it can be pricey. So I'm going to try to do my best to provide you with training opportunities. The Division of Risk Management does these trainings. I oversee all of the civil rights laws, so I don't have the capacity to do all of them, but I'm going to do my best to at least provide you with some resources that you will have to post those training materials that you've used online for all to see. And of course, you need to pay attention to copyright issues. So there are the requirements. So you can see that this is going to be challenging with staffing and training, especially since they're saying, oh, this all needs to be in place August 14th. So hurry and get trained. When everyone else, even the ATIX organization, which is where I received my training, they're scrambling to get their trainings up to date. So this is part of the process here. You can say, I got this training on the basics of the regs. So we've been looking at the policies according to this training. And then you can, of course, post this. We'll have the recording. I will be so excited to have me on your website, but whatever. Whatever I can do. Western Educational Equity Assistance Center, I've been consulting with them. They have free training. And it's typically 2 days, but there's different trainings for investigators than there are Title IX coordinators. So, and I have not heard of decision maker trainings, but so I don't know exactly what that looks like. So these are challenges, but you will have to follow these regulations. So, all right, breaking that news to you. So standard of evidence, when you have to select a standard of evidence. This is a little cloudy to me. I had to consult with the attorney, the Assistant Attorney General at our office, because I'm not an attorney, and to understand preponderance of evidence and clear and convincing evidence. I had no idea. How do you distinguish between those? And you get a choice. So when you're determining responsibility and looking at evidence, you get to choose one of these 2 standards of evidence. So, and you have to be consistently using that standard throughout all of your decisions. So a preponderance of evidence, this is that your inculpatory, exculpatory evidence that has been submitted mathematically proves the responsibility if it's kind of like over 50%. I don't know how you determine 50%. But then clear and convincing evidence is a heightened standard, so of demonstrating responsibility. So it's essentially a higher standard. I had an example that the AG gave me that seemed to pretty much help me understand it. Let me find my notes here. Okay, so he said a comparison. So you've got beyond a reasonable doubt. So that's when we're looking at a court determination of innocence or guilt. That's the highest standard. So that's when you're convicting a person of a crime. So clear and convincing lies somewhere in between. The lowest standard proof would be preponderance of evidence, and and then clear and convincing, and then beyond a reasonable doubt. So you just get to pick one. And I would say consult with your legal counsel in all of these things. I am not an attorney, but I hopefully described that well to you with the information I got from an attorney. Okay, so now we're going to talk about FERPA concerns. And this is where I was alluding to earlier about parties being able to access evidence that has been submitted. They have the right to access the evidence related to the allegations. And so you can imagine this could have information about other students that you're not able to redact. Again, this is working with your legal counsel, because I don't want to touch this. The regs say that Title IX requirements are consistent with FERPA, but definitely there's some things that make you go, so you can't, there are some definite things that you can't access and that, or consider, disclose, or otherwise use. And it's describing this as your physician, psychiatrist, psychologist, or other recognized professional or paraprofessional acting in professional or paraprofessional's capacity. Now, if a party were to submit that to you, it's not like you say, I can't look at this. You just can't seek it out. But it says consider, disclose, or otherwise. So it's just tricky when you're looking at these real sensitive health, mental health, physical health related issues. So just be really careful with that. So, and as I said, if you obtain the party's voluntary written consent to do so. So they might really want you to consider that evidence. Okay, continuing with FERPA concerns, they have a right to choose any advisor that they want for all to have present with everything. So they're going to hear sensitive information and be provided with these copies. So they're going to hear students' names and things. And then when you give them the determination, you have to have the rationale, and sometimes that might disclose some information. So again, work with your attorneys, your administrators, district administrators, Title IX coordinator, because I have some FERPA concerns, even if the regs say that it's following FERPA. And I gave this information because all of this information that I have presented to you is directly from training from Office for Civil Rights that I've had within the chunk of time within the last month. ATICSA, which is the most reputable organization of Title IX. I'm not trying to promote any one product, but that is the training I've received, and it's the most reputable organization that I am aware of. So training that I've received from them in the past month, and conversations I've had with the Western Educational Equity Assistance Center. So I'm providing you hopefully with the most accurate information possible. And I submitted this to our data privacy people at USBE, so hopefully you can get more guidance on FERPA. This is certainly not my primary expertise. Okay, so parties have the right to appeal when you submit the investigative report, your dismissals, your investigation results. And so here's the ground. So if they say that there has been a procedural irregularity, so let's say that they feel like one of the investigator was biased. Maybe they got new evidence that was not available at the time. So they can appeal and say, hey, we've got new information. The conflict of interest and other things, as long as and they apply on an equal basis to the parties. And here's what your appeals process should look like. Again, we're notifying in writing simultaneously that there has been an appeal, and then they both have the opportunity to submit a written statement of support or disagreement. And then the person who decides on the appeal, so here we're going to throw in another person. So you have an appeal, you can't use the same person who served as the investigator before or the decision maker. So now you've got a whole new set of people that are involved in the appeals process who need to have training. So this is all like, I don't know how much they thought about this, and I know we need to provide fair and equitable treatment, and this is a serious topic. But our infrastructure, is our infrastructure in K-12 really, do we really have the capacity to do the things that they're asking us to do? Are they providing us with more funding to do this? I have the same heartburn as you do about these regulations, or the heartburn I'm assuming you have. It's going to be a heavy lift. So after reviewing the news, what's been submitted, the appeal, and looking through the new evidence or whatever they have available, the written statements, then the new decision maker has to issue the decision to both of the parties simultaneously. And then after that, it's done. So at that point, if they're not happy, they've appealed to the district, they can go to the Office for Civil Rights, they can retain an attorney, they have options, they have recourse, but you're done with the process. And really when it comes down to Office for Civil Rights involvement, they really come in, if there's investigation that they open up, they come in and see how tight are your policies, how well did you follow them. Those are the main things that they will look at when it comes to an investigation. It's not even necessarily the decision you make, it's how did you follow them? Was there deliberate indifference? Was there retaliation? Did you go through your grievance procedures appropriately? And those are the things that they look at. And in my job, you know, this is the language that I'm hearing all the time. And so I always think worst case scenario, which we hope never happens, but I do have to let you know what the worst case scenario is so that you can protect yourself and your students with your policies. And that's why these were made, which I appreciate. So we talked about informal resolution, and this is an option. It's not something any LEA needs to do, but they do need to offer that up front. When they receive actual knowledge, they need to say, here are options. This is something that you could use. Both parties have to enter it voluntarily, so you can't force them to do this. You have to have a facilitator, again, who has no conflict of interest or bias. And then you need to provide them with the allegations, the notice, the information about whether the information is informal process is confidential and withdrawing from the process, because they can file a formal complaint at any time. They don't have to move all the way through the informal process. And okay, record keeping. Just like your taxes, keep them for 7 years. And it needs to include all of this stuff. So remember I said you got to document everything. I don't have any formal documents, you know, that maybe that's something in the future that I could look at providing some kind of formalized document, but certainly I can work with the TICSA, with WEAC, and see if that's something, but you, at least at this point, need to come up with your own that records the investigation, appeals, anything that was written from the parties. So everything here you need to keep in your files for 7 years. And that even includes the materials that so you can demonstrate that the coordinators, investigators, decision makers all have training. They're really sticking with this, making sure they're trained. And I get that. I do. If they don't have, how can you have a fair process of investigation and determination if you're not trained to do so? Because it can be kind of tricky. You don't, when I've gone to investigation trainings, it's a little intimidating. It's a little intimidating when they talk about the scenarios, sitting down with the parties, not asking leading questions and things like that. And it's not like this happens all the time. So it is a little intimidating, and you want to make sure that you're being equal with both parties. So I get it. It's just, like I said, it's a heavy lift. So, so right now, tricky time. We are coming on August quickly. And this is what ATICSA recommended for some stopgap measures when this happens. So you can, between this point and then, you can proceed the way you're going right now with your current policies. There's some things impacting right now our decisions and making those things happen. So that's a choice. You can pause the findings, the current recommended findings, and but not your investigations. You can't pause those until you put the procedures in place. And so, and then you can implement a set of procedures that moves toward compliance with the new regulations. So kind of a hybrid of, here's what we got, here's moving forward, we want to put these things into place. So let's start to build those, weave those into what we're doing right now until you're building it. I don't have recommendations one way or the other, but these are some recommended stopgap measures between now and when we get there. Okay. So we've reached the end. I just want to add this disclaimer. I'm not an attorney. So really work with your legal counsel, your district administration, as far as the decisions. This is, we know this is a serious matter, and we want to proceed carefully and be on point. So, but I am not an attorney. So I recommend that you, if you have some questions, to work with your district and legal counsel. Again, another bill to pay. So these are some of the places that I talked about. And I've got links there, and I'll be sending the copy of this to whoever the organizer was for this event that wants me to send them to. Oh, hi, Michael. Thanks for joining. So that's it. There's my contact information if you need to get in touch with me. I didn't see any conversation or questions come up in the chat. It's a lot of information, and I'm surprised I got through it in an hour. I'm feeling pretty proud of myself right now. So any last minute questions before I let you continue on to maybe some more lighthearted presentations? Okay, so you know how to get a hold of me. I'm still in the process of learning, and you do have some other resources available, and I'm always happy to try to get questions answered and try to get you whatever resources that I can that come out of the Department of Ed or whatever connections that I have that can provide you with support. So thanks for joining, and I hope you have a good rest of your conference and stay well. Looks like we just have Michael on. I don't care if he hangs out. He can hang out. Mercedes, did we get that all recorded?
Mute me. Yes, I got it all recorded. Make sure I. My little thing went away though, so I'm trying to make sure I'm not still recording. Did you go?